What is discussed on this program is meant to be for general information and educational purposes. It is not intended to be legal advice and should not be used for that purpose. If you have legal matters you need help with, then you need to seek the advice of an attorney.
Welcome to another edition of Legal Briefs. Legal Briefs is produced by BBKCC attorneys in cooperation with WCTV as a community educational program about the law and involving legal issues and hopefully providing education to the general public in various legal issues. My name is Rick Boston. I'm a partner in the BBKCC law firm, and with me today is one of my law partners, Doug Oler. In this edition, we are going to focus our attention on what can be done to protect your assets from creditors or other third parties. Focusing primarily on a brand new estate planning tool that has only recently been allowed in the state of Indiana, actually since July 1st when the Indiana legislation took effect. And this is commonly referred to as a legacy trust. So at this time, I think we're ready to begin. And Doug, if you'll just kind of give us a little intro on about the legacy trust and what they can provide, and then we'll move from there into some more details.
Thank you, Rick. It's nice to be here with you.
Thanks.
Basically, as you said, effective January 1, Indiana has a new estate planning tool that we can use in our toolbox. It changes the Indiana law to allow people to create a certain kind of trust that allows them to protect their assets from creditors, and at the same time give them the flexibility to receive the income and maybe the principal from that trust. Indiana is the 18th state now that it has permitted that. It follows, I think Michigan and Ohio recently adopted them, so we're falling in line with our neighbors here.
Okay, and I think during this program, I know I will probably tend to refer to these as legacy trusts. There's a more formal name, a domestic asset protection trust, or what's apparently going to be referred to as DAPS, D-A-P-T-S. I think we'll kind of break the program into 4 different areas, look a little bit at the background of asset protection and the use of trust generally that has led up to the legacy trust legislation. Second, what are the requirements to create such a trust? And then third, the purpose of the trust is the protection of creditors, so we'll go into more detail on that. And fourth, creditor exceptions. That is, there are certain creditors in certain areas that are protected, and the legacy trust will not protect you against those particular trusts or those particular entities. So I think let's begin with the background on this. And Doug, before we start, I thought it might be helpful if you kind of define 3 or 4 terms that they're involved in all trusts, and our audience will be hearing us refer to these throughout the program, and it'd probably be a good idea that everyone understands what those are. And I would start by self-settlement trust. What is a self-settlement trust?
A self-settled trust is a trust that an individual creates for themselves. I take my assets, I create a trust, I'm the trustee, I control those assets, and it's strictly the income and principals for my benefit, and then on my death it distributed someplace else. But that self-settled trust means that the settlor, or the one who creates the trust, is the one who created that trust.
Right. Okay, and I think I misspoke. I think I called them self-settlement trust. It's self-settled trust.
Self-settled
yeah,
trust.
But the other definition or defined term that I would ask you about would be a spendthrift trust. What is that?
A spendthrift trust is where you put a provision in the trust that says the beneficiary cannot is restricted from what they can do with that trust. They can't spend it without somebody else's, the trustee's discretion. They can't mortgage it. They can't transfer it. It's called a spendthrift trust because it's designed to keep that beneficiary from spending it unwisely. And so the transferor or the settlor has created this spendthrift provision to restrict them from themselves.
Right, and what we may get into expands that to maybe include the settlor or the creator of the trust that may give, which may be restricted as a spendthrift provision, which this may be opened up with the legacy trust. The other terminology that we might go into would be referring to a transferor or a settlor.
That the transferor or the settlor is the person who creates the trust.
Okay. At this time, why don't you give us a little background of what Indiana has had in the way of trusts for the protection of assets and that type of thing leading up to the passage of this legacy trust statute?
You're right, Rick. Asset protection is not necessarily a new concept in Indiana. Over the years, there have been a long list of exceptions to execution of judgments, meaning there's been a long list of income and assets that you can protect, such as in garnishment, wages, a certain amount of wages is protected, pensions, life insurance, homesteads, workmen's compensation proceeds have always enjoyed some degree of exemption from creditors reaching them. And so we're adding another tool to that estate planning toolbox that we've got. Also, through the years, there's historically, not just in Indiana, but in the United States, creditors have had some protection from the law through the fraudulent transfer statutes, meaning that I can't transfer my assets with the intent to defraud a creditor. So historically, it goes back to Roman days, in fact, fraudulent transfers have always been protected.
Right. And I think with fraudulent transfers, I think you've got I believe Indiana has about a 6-year look-back period. So if you transfer assets, with the intent to hinder, delay, defraud your creditors, then the creditor can set those transfers aside, bring the asset back to satisfy their judgment if it's within a certain period of time, and each state has their own time frame on that. How about spendthrift trusts? What's the history of that in both the U.S. and in Indiana?
In the United States, a spendthrift trust goes way back to the early 1800s. Thomas Jefferson, for example, created a spendthrift trust to protect his daughter's inheritance from creditors of her financially troubled husband. And so that may have been the first real example of a third-party spendthrift trust in the United States, but it's been there for many, as you can tell, from many centuries, in fact, now at this point.
Right. And then using a couple of the terms that we talked about early on in the definition of a self-settled spendthrift trust, was that, as I understand it, those were not allowed in Indiana. They were frowned on, and the
well,
use
they
of,
were not allowed in the United States until, I think, 87.
Okay.
Some creative attorney in Colorado talked the Cook Islands into allowing him to create a trust and put his assets in that trust and avoid creditors. And so as what happens, what you would expect to happen, there was a tsunami of money rushing to the Cayman Islands and to other islands in that area. And so finally, states caught on that this transfer of money was occurring, so they started adopting these, what we're talking about, legacy trust today. I think it started with Alaska and Delaware, and now Indiana is the 18th state to create these trusts.
Right. As you say, I think a lot of it was driven by the fact they were monitoring the flow of money, and it was going into people in Indiana were moving their money to other states where they could find protection with the legacy trusts that those states had adopted and legalized long before Indiana had. And I think with all of this, I mean, there's two different of areas that converge that have been difficult. You're trying to protect your asset while at the same time allowing you to use those assets for the benefit of yourself.
That's right. There's two goals there you're trying to accomplish, and they don't necessarily go together. One is to protect your assets, and the second is how do you protect your assets by sufficiently and yet retain enough flexibility to have the income and principal available to you.
Right, and that is
That's
more or
what we're
less
gonna be
what the
talking about
legacy
today.
trust
Yeah.
and what we're going to be talking about through the rest of the program. So I think we can move now to the requirements to create a legacy trust. So the statute is very specific in what those requirements are. So let's just kind of start through those. And
yeah, it is specific, and it's long, and it's new, and so I'm going to do some reading too.
Yeah.
But basically, the trust has to be in writing. That's a pretty obvious one. The trust must designate, it must say that it is a legacy trust established under the Indiana Legacy Trust Act. And then next, it must include the appointment of a qualified trustee. That qualified trustee is defined as an individual who is a resident of Indiana or an entity that is subject to the Indiana Department of Financial Institutions or subject to the control of the currency, which basically means that the entity needs to be a bank or financial institution with trust powers. So we have, the trust has to set up a trustee, and by the way, I think I omitted that cannot be the transferor.
right.
So we have to set up a trustee that cannot be the transferor. Indiana, the statute says that the trust has to be governed under the laws of the state of Indiana. And this is really a big one. It has to be irrevocable. And we may need to talk at some point here about the difference between a revocable trust and an irrevocable trust. But this trust has to be revocable, meaning once that it's done, it can't be changed, it can't be amended or terminated. And the trust has to have a provision in there that says the beneficiary's interest cannot be voluntarily transferred, assigned, pledged, mortgaged. That's the spendthrift
provisions.
Mm-hmm. So those provisions have to be in the trust. In addition, when we go on to the next provision, once we name a trustee, a qualified trustee, then it says that the transferor must execute a qualified affidavit. And in that affidavit, the transferor has to swear that certain things. And here again, I'm going to refer to my sheet here because it's lengthy. The transferor has to say the transferor has title and authority to transfer the property, must own it and have the rights to transfer it. The transferor must not render the transferor. The transfer must not render the transferor insolvent. Mm-hmm. The transferor does not intend to defraud a creditor by transferring the property. So those are all pretty significant things that you have to say in the affidavit. And they also has to go on, and the affidavit has to go on and say that there's no actions pending or threatened any court actions threatened or pending against the transferor, and that the transferor is not involved in any administrative proceedings other than the one identified in the affidavit. The transferor does not, this is an important one, the transferor does not contemplate filing relief under the Federal Bankruptcy Code. And lastly, that the property being transferred is not derived from unlawful sources. So the statute is very detailed on what the actions of the the trustee are, who the transferee has to be, and also the fact of an affidavit has to be signed and what has to be in that affidavit.
And by being an affidavit, it's going to be under oath.
Correct.
And obviously, if any of these representations are false or turn out to be inaccurate, then I would assume that the trust could be set aside or voided, and the creditor could probably pursue the assets that you attempted to place in the trust.
That's the risk you run for failure to comply with this statute strictly.
Right.
Yeah.
So it's certainly not for an individual that might be been in a serious accident. It was their fault, that might have exposure for damages, personal injury or property damages in excess of their insurance coverage, that type of thing. It's not going to protect them if they've had this accident or they know about it, or there's facts that would indicate to them somebody's likely to sue them, or they're going to have a claim because of something they've done or not done or whatever. So you're not going to get protection. It's too late at that point to be setting up a legacy trust.
That's correct.
And again, as you said, it's not going to protect you from bankruptcy.
Yeah, we can't emphasize that enough.
Right. Yeah. I mean, it's and certainly with the bankruptcy, you would have to set up the trust and go 10 years before a trustee would be in a position, or you'd be in a position that the trustee couldn't set that trust aside, and because the trustee under the federal bankruptcy laws has pretty broad
Yeah, we're going to get into that
and,
again in a minute, but that's right. There's a 10-year look back for the bankruptcy trustee. It can go back and void these transactions.
Right, because under the bankruptcy code, basically any self-settled trust before the legacy trust or whatever, where the trustee still had power over the assets, the trustee steps into the shoes of the transferor or settlor and can do whatever they can do, so they can set all this aside and pull the asset back and liquidate it for the creditors at that point.
In summary, those requirements of setting this up are very, very restrictive to the point that you should never try to do one yourself. And also because the law is so new, they need to see their attorney before trying to attempt this.
Right, and we might, as a caveat to our listeners, we might say that, this law is new enough. There's not been any case law decided on it, no interpretation. So we're reading the statute, and as other attorneys around the state are trying to kind of get our hands around it and hopefully
understand what
interpret
it means
accurately and understand it, because it is a fairly complicated statute. But it does provide for the right circumstances some good protection from your creditors. Let's go back to the trustee. You talked about who you had to use as a trustee, but as far as there are kind of multiple layers. You have the trustee, but then you can also have other directors and advisors that can be named in this trust as well.
That is correct. You can have an investment. You can have an investment advisor. You can have an administrative advisor, and you can have an advisor over the distributions. Remember, in this trust, the trustee has discretion to make the distributions of income and principal, not the transferor. So it's really important who you're going to name as trustee. And may want to have an advisor to the trustee, hopefully who will do what you would like to have done.
Right, because it is, is one of the changes, that it does allow you to use the principal and income off an irrevocable trust, but you don't dictate, what you need
cannot
and what you
control that.
want like you
Right.
can under certain trusts.
Right.
So that is one of the limitations.
That is correct.
And as I understand it, I think that the transferor or settler of the trust can provide investment advice to the financial investment director, but it's only advice. The director makes the final decision,
That's
and
correct.
he wouldn't have to follow that advice or.
That's good.
Okay. Well, let's move on to the exceptions of what creditors you would not be protected from under a legacy trust. So you set up your trust with the purpose of protecting your assets from your creditors. So the statute provides a list of various types of creditors that would not be affected by this legislation.
Yeah, I think the first big one obviously is the fraudulent transfer case. There's still protection there. That goes back to, as I said, to the Roman days, and it still continues on. You cannot create this trust if you're creating it for the purpose of evading a creditor. That protection is still built in there and will always be there. Thing.
Right.
The second one would be child support. You cannot create one of these trusts to get around your a court order on child support, for example.
Right, and I would assume that, I don't know that what I've read indicates, but I think when they talk about child support, I would think that could be expanded to court-ordered maintenance for a spouse, that may be disabled or whatever. Yeah. So,
and it expands it to the next exception is marital property settlements.
Right.
It expands it to that too.
Right.
If you have a court order on how to divide property in a divorce situation, you can't set one of these trusts up to avoid that court order.
Right, right.
Then the next one is a big one, which you're know much more about it, is the bankruptcy clawback, I call it.
Right.
It's the provision that says that in the statute that says that you cannot create these trusts and file bankruptcy within 10 years, and it will be voided. The trustee in bankruptcy has the authority to reach in and grab those assets and void that trust and bring it back in.
And then I think it also affects your financial statements, that you've given to a bank that you can't avoid. If you've listed these assets on a financial statement and then try to transfer them into a trust, that's not going to.
If you apply for a home loan and you put your assets on a sheet and give it to the lender, you then can't transfer assets that are on that sheet. That can be considered a voidable transaction.
Right. And some documents you already have, on mortgages or so forth, may even prevent this type of transfer. You just read the language.
I suspect we'll see that in probably all mortgage applications in the future. Don't you think so?
I think so. Yeah, definitely. And I guess we don't have much time left, but one thing, Medicaid always is a question. Can you protect assets from Medicaid? If that's a question we get regularly from people, how do I protect my assets from Medicaid? Weekly, daily.
The answer is no. Medicaid has a rule that says you cannot create a self-settled trust, meaning I can't create a trust for myself and then file for Medicaid. That's an absolute no-no. So you can't avoid get on Medicaid by creating this trust.
Right. So I think we're getting close to the end of our time, and I suppose maybe there's a few uses that I think these can be used for. You might just mention those kind of in passing so that people will know areas that they might look at one of these trusts to be used for.
Well, keep in mind what we're trying to do is remove the assets from the transferor's estate and yet give the transferor the income and principal. The reason why we want to remove the assets from the transferor's estate is in large asset individuals, it lowers their value for estate tax purposes, can reduce or eliminate their federal estate tax. And so that's one of the things that might work to your advantage if you're at the federal estate tax exemption or above. You could create a trust and reduce your assets to below the exemption, which is in excess of 11 million. And
okay.
Are we?
I think we're
okay.
about out of time here, and so I think we probably ought to call it a halt to our discussion. But we appreciate you joining us in this program and spending some time with us. We hope that you found this presentation both interesting and helpful. And as always, if you have legal topics that you would like to see us address at these future legal brief presentations, you can just call our office or email us. The web address will be provided on the screen for you so that you can go to our web page and get any information you need, contact information. So just let us know if we can present something that you have a particular interest in. Thank you.
What is discussed on this program is meant to be for general information and educational purposes. It is not intended to be legal advice and should not be used for that purpose. If you have legal matters you need help with, then you need to seek the advice of an attorney.